Jonathan Pollard, Florida employment lawyer. I'm going to give you an update on my first 100 cases. So as many folks know, we spent probably 10 years mostly focused on defending non-compete and trade secret cases. And ultimately, as that was constituted, we would defend everybody from C-level executives, entrepreneurs, rainmakers, folks who controlled $20 or $30 million worth of business and who could pay substantial fees for our representation, all the way down to janitors, factory workers, security guards, folks who we would represent on a pro bono or contingency fee basis. So we did that for about 10 years. And that's when I decided that I wanted to shift my focus primarily to plaintiff side employment cases, because I identified what I perceived to be a tremendous market failure in that area of law. Okay. Essentially, you have plaintiff side employment lawyers, not all of them, but most of them, settling these cases, the real plaintiff side employment cases, for what amounts to relative peanuts versus the actual value of the case if you ride it out, you grind it, you litigate it, you take it to trial. So, we have a situation where cases that, per my appraisal are worth minimum $300,000. If you get past summary judgment, if you get to trial, even more, being settled for $30,000 or $40,000 up front. So to demonstrate proof of concept, I've invested at this point over $1 million, probably close to $1.5 million on advertising, marketing, acquiring all of these plaintiff side employment cases so that we can then hand pick the most egregious plaintiff side employment cases, file 100 of them, and essentially demonstrate that, yes, there are a bunch of bullshit claims and allegations out there in the employment space. That's undeniable. Most employment grievances are absolute horseshit. They are not actionable. Your feelings are not the same thing as your rights, okay? But that said, there are still thousands upon thousands of legitimate plaintiff side employment cases out there that are settling for 10% or less of what the case is actually worth from a settlement value standpoint. So what are we working on, right? With that sort of background and that framework, we are getting close to our 20th case that we have rolled out. And so far, the majority of the cases that we are pursuing fall into a couple different buckets in terms of substance. Why am I going to explain this, right? Well, for a variety of reasons. Some people are very interested in seeing where this goes and how this goes. Number two, we get several hundred phone calls, emails, messages, inquiries every week. So it's beneficial if you are going to contact our office to understand really what we are interested in pursuing, okay? And I hate to be a big meanie and a bald-headed jerk-face meanie, but it's my law firm. It is a business. We do a tremendous amount of pro bono work and charitable work, but at the end of the day, what I'm talking about here is core business. Yes, it is socially beneficial. Yes, these are righteous cases. Yes, these cases correct tremendous injustices out there in the workforce. But at the end of the day, I am only taking the cases that I want to take. I am only taking the cases that meet my predetermined and pre-established metrics. So here's what we are really looking for, and here's what the vast majority of cases that we've either filed or settled early on tend to look like. Number one, race discrimination, okay? There's a lot of folks out there in America who think that everything is racist. And then on the flip side, there's a lot of folks who think that racism no longer exists. And both of these groups of people are full of unmitigated horse shit. Because of course racism still exists, right? Not everything is racist. I don't buy into this whole concept of microaggression theory, but be that as it may, there is still naked, ugly, egregious racism in existence in America, and it's particularly prevalent in certain parts of America and from a labor market standpoint in certain industries. Interesting tidbit to note, one of the most common industries that I see for everything, not just racism, but sexual harassment, sexual assault, any type of discrimination, but particularly racism and sexual harassment or sexual assault, construction. The construction industry is an absolute hotbed of racism, discrimination, sexual harassment, and sexual assault. You take a construction company, $50 million in revenue, at any level of that organization, you know, the GC, the subcontractors, the electrician company, right? I see so much blatant, egregious racism, sexual harassment, and sexual assault coming out of that particular industry. So the first big bucket is racism. I see a lot of blatant racism, particularly directed against Black people. And strangely enough, I see a lot of that coming out of the construction industry in Florida. One of the reasons why, you know, South Florida is sort of its own universe, right? You're south of West Palm Beach, but you get north of West Palm Beach, you are in the American South proper. Florida north of West Palm Beach is the South. And there are vestiges of all of that, right? I'm talking historical, racism, prejudice, bigotry, etc. We just got a race discrimination case out of the construction context where a supervisor would ride around on a golf cart with a gun, right? Open carrying a gun and screaming the N-word at Black people who would be digging in a pit, right? You can't make that kind of shit up, but that stuff really does still exist in Florida and in the construction industry. So we see a fair amount of racism, race discrimination cases, particularly directed against Black people. We do not run those cases as Title VII, okay? And that's for people who know something about the law or are interested in understanding more of it. Title VII is the main employment-related civil rights act that protects against a variety of different types of discrimination. But Title VII is, in many respects, a paper tiger. Yes, you can have some exposure, you can have some damages, but in 1991, Congress gave corporate America a massive handout, right? Corporate welfare, by what? Capping the damages available under Title VII. As originally passed and constituted, there were no damage caps in Title VII. Congress circled back in the early 90s and did that as a favor for corporate America. And so you have these damages caps right up to $300,000 in compensatory and punitive, depending on the size of the employer. And those caps have not been adjusted since they were passed in 1991, I believe it was. So here we are, some 30 years down the road, with inflation, with all sorts of other federal statutes having cost of living adjustments, et cetera, but damage caps on Title VII, nope, they've stayed the same way. And there's a tremendous amount of judicial activism in that direction as well, where even on non-Title VII claims, courts and certain judges look to Title VII as sort of a benchmark for what is reasonable. But is it reasonable for us not to take into account inflation, right? I don't think so, but none of this passes the smell test, right? I ultimately believe it's all just a big shell game. And, you know, I do what I can. I win the cases I can. I get the justice I can get. But at the end of the day, I don't really trust or believe in the system. I think it's all a con job against like working and middle class people in America. But so we see race discrimination cases. We don't run those as Title VII. We run those as 1981, 42 USC 1981, the original Civil Rights Act, right on the back end of the Civil War. Why? Because there are no damage caps. You can get unlimited compensatory and punitive damages. That's why race discrimination cases are like top tier. The egregious ones, the real ones. No, I'm not talking about microaggressions. No, I'm not talking about somebody ate the last cupcake and didn't invite you into the break room for Sharon's birthday party and you feel that it was discriminatory because of your race. Like, just shut the front door. I'm not interested. I got the real stuff, okay? That's one. The second big bucket is sexual harassment and sexual assault, okay? We see not only cases involving inappropriate sexual comments, propositioning, quid pro quo sexual harassment, et cetera, we see a fair amount of actual outright assault cases. Now, remember, a lot of people don't, quite put it together. If somebody in your workplace is actually touching you without your consent, that is sexual assault, right? And I've covered this at length over the past few years. We've had everything from workplace outright rape cases to situations where you have, for instance, a senior executive who is Mr. Handsy, right, with the assistants, the office staff, etc., right? There's a new administrative assistant who's, 27 or 28, the senior exec, goes in and starts making it a habit of going to her office, massaging her shoulders. Oops, his hand slips down onto her breast, right? He wants a morning hug. Like, that's not just sort of harmless. Oh, he's just kind of old and that's just his way. He's very friendly. Like, no, that's not what that is. That is sexual assault. That's not just sexual harassment. That is sexual assault that cannot be tolerated. There are no excuses for it. And yet, so many companies, including big, sophisticated companies with lots of money, in-house counsel, etc., even accounting firms, law firms, big finance companies, they try to downplay that and justify that and make excuses for it. They try to say, oh, well, it didn't really seem that bad. We don't think it was sexual. Like, in what universe is some pervy 65-year-old guy coming up behind a junior secretary's desk, putting his crotch all over her back and trying to grab her breasts? In what universe is that not blatantly sexual? And in what universe does that not constitute assault and therefore sexual assault, right? Pretty basic fucking logic. But we see a lot of those types of cases. And strangely enough, once again, we see a lot of those coming out of the broader construction industry. We see it with the general contractor, the women who work in the office, women who work out in the field, right? In construction trades are particularly susceptible to sexual harassment and sexual assault. And so we have a number of cases that go in that direction. Perhaps an interesting note on some of the sexual harassment and sexual assault cases: the plaintiffs in these cases that we have, both filed and still in the investigatory stages, they're not just women, okay? It is a complete falsehood to suggest that men cannot be the subject of sexual harassment and sexual assault in the workplace. We have one case right now where an older gentleman in his 60s, straight, was being sexually harassed and sexually assaulted by his superior, right? So that sort of situation does happen. And unfortunately, on those particular types of cases, there's such a tremendous stigma that a lot of men are afraid to come forward and talk about what happened. Well, don't be, don't be. You can talk to me about your case. You can talk to one of our paralegals. You can talk to one of our assistants, or, if you need to talk to another man about it because you feel more comfortable talking to another man about it, who will understand, you're welcome to talk to me about it. But we see a lot of sexual harassment, sexual assault cases. And, interestingly, once again, coming out of the broader construction industry. The third big bucket of cases that we see is age discrimination. I see a tremendous amount of age discrimination. And this is not limited to any particular industry or sector of the labor market. This is just sort of comprehensive, universal. Age discrimination against folks who are 50 and up, but particularly 60 and up, is a growing trend. And, when I talk about trends, what folks have to understand is I'm seeing, in an average week, 500, 550, cases, leads, potential matters. So I really do have enough data to start, drawing some conclusions about what is trending out there. And age discrimination is one of the big buckets of cases that we are seeing these days. Jonathan Pollard, employment lawyer, Fort Lauderdale, Florida. If you have a potential plaintiff side employment matter, whether it is discrimination, retaliation, sexual harassment, sexual assault, feel free to contact our office, 954-332-2380. Again, 954-332-2380. I cannot guarantee you that we will take your case. In fact, we do not take 98% of the cases that come across our desk, but we will let you know whether or not we feel your case meets our standards. And if it does, we will pursue it, and we will do so aggressively and with zeal. Thanks for watching. Have a good day.